filed the motion for summary judgment, and it appears on statute of limitations and it appears that the defendants have conceded, or the plaintiff has conceded, at least with respect to the 2-year statute of limitation causes of action, because they actually provided no response in the least regarding those items. But the gist of the motion, of course, is, as we briefed, the causes of action that they've alleged are based upon conduct that began, they say, in and or about the year 2009, and then all the way up into their newly amended pleadings up until 2018. Their original causes of action was from between 2009 to about 2017. And the evidence, on the other hand, shows that, in fact, Ms. Watson had started doing the books for the company in or about 2001. And Daniel Watson did not have his own bank account. And so as a result, and the evidence is uncontested in this matter. He did not disagree with this. We have the affidavit of her stating that she was instructed as early as 2001, literally 20 years ago, Judge, to take his income and pay him directly out of everything, pay the household bills, pay for personal belongings, as she says in her affidavit. Daniel did not have a personal bank account since I started working in the office in 2001. As a result, Daniel Watson would simply have me pay for almost everything from accounts held by Angel Sword LLC. That included everything from mortgage payments, rental payments, credit card bills, utility bills, very expensive and rare alcohol, men's apparel, opera, gala events, dining with family or friends, and the list goes on, including jewelry and fur coats and everything, their mortgage. All of this was being operated out of the Angel Sword Corporation and then the Angel Sword LLC accounts, as she states in her affidavit. And they don't contest that. What they contest is they're trying to assert that this man was, quote, blinded by love for 2 decades, such that he wouldn't decide to conduct any sense of reasonable diligence associated with the management of his business. And the uncontroverted evidence indicates that no, he actually was getting paid that way. She was seeing, he was looking at the accounts periodically, but for the most part, he left the day-to-day bookkeeping with her. And those decisions included not paying payroll taxes that became due in 2006, 2007, and 2008, such that the Texas Workforce Commission in 2009 filed a very public lien against the entity. And as the uncontroverted evidence further shows, that the reason why Daniel Watson created Angel Sword LLC, the successor in interest to Angel Sword Corporation, was the Texas Workforce Commission had leaned up the corporation, and he didn't want to pay the tax or the payroll liability that he had incurred. And interestingly enough, I'd forgotten the whole basis for why the Texas Workforce Commission had even gotten involved, and it was because Daniel Watson didn't want to pay a personal injury claim made by one of his employees because he didn't carry work comp, and then the employee reported that, and so the Workforce Commission starts digging around a little bit, and they ascertain, oh, well, you know what? Besides that, you're not paying your payroll taxes, and so he tried to circumvent that by creating the LLC later on. And all of that evidence regarding the time is uncontested. And so moving forward in 2012, Daniel Watson tells the manager, Brant Noel, I think Oksana is stealing from me in 2012. So in 2001, she's been doing the books the entire time. all the way up until around 2016, 2017. Perhaps around 2015, there's some interaction with Jeremy Levy, but for the most part, Daniel Watson had her running the books beginning in 2001 and going all the way through, all the way up till about 2015, 2016. And as early as 2012, he's telling Brant Noel and then also people at the Renaissance Festival, Oksana Watson is stealing from me. But he doesn't file suit in 2008. He doesn't file suit in 2009. He doesn't file suit even in 2012. Indeed, he doesn't even file suit against or have Angel Sword Corporation and the LLC file suit against her for these breaches of fiduciary duty all the way up until May of 2020. Literally after he had tried to have her indicted and successfully had her indicted, but the prosecution was dismissed once they found out what a sham it was.
Let me ask this. I've read all the briefing, so I've heard the arguments. I guess the area that I'm really kind of struggling with, and Mr. Vassar, it did not appear that you responded to the summary judgment for your 2-year causes of actions. So are you conceding those? Mr. Vassar, you muted.
Not necessarily, Your Honor. We did plead the discovery rule. We filed a supplemental petition, and there's evidence that some, at least of the tax issues, continued into last year. So we're not necessarily conceding that, Your Honor, but I do think they have a real problem with fiduciary, getting a judgment on fiduciary.
I'm going to grant the summary judgment on all the 2 years, and I do think breach fiduciary duty. So this is where I struggle with this. And where I struggle with this is that there seems to be some conduct. There's a lot of conduct that's alleged to have been a breach of fiduciary duty. Some of it probably is pretty clearly beyond the statute of limitations, and some of it may not be, at least it'd be a fact issue on it. And I guess I don't really know enough. I know some of the conduct that you're alleging, Mr. Vassar, breached the fiduciary duty, but I don't know all of it. And so I'm trying to just think conceptually. Let's say we agreed with you, Mr. Vassar, on the breach of fiduciary duty. You know, that there is some of it that still survives. How would this be charged to a jury? Would you know, there's a jury charge question on the discovery rule. One thought I had is that, you know, we could give an instruction at the charge, you know, in the charge along the lines of, you do not consider anything that happened at least 4 years prior to the discovery of the breach of fiduciary duty. I'm just not sure. This is really complicated because there's so many individual acts that you're claiming are breach of fiduciary duty. And so that's where I guess I kind of struggle with this.
I agree with Your Honor, and I think you have identified the most logical way. What I've seen in summary judgment cases, though, is you really can't carve anything out at this point. I don't know that Your Honor was suggesting that you do that, but I think in the summary judgment cases, if they're going to get a summary judgment on some of the breaches of fiduciary duty as time barred, then they have the burden to go ahead and point out what exactly is time barred in a very specific manner. So I think if you're going to grant, if you're going to leave those fiduciary duty claims, that is something for down the road, as Your Honor may have suggested.
Judge, that is the idea of shifting the burden to the defendant is absurd in that context, particularly since the way they pled the breach of fiduciary duties with respect to the, I guess what we'd characterize as embezzlement claims, right? They had kind of three categories of claims. One was this sort of, you know, incompetence associated with the filing of the payroll taxes and the I guess the income taxes, and that those things had supposedly begun in and around the year 2006, and then continued, I think, up until maybe 2009 or a little bit later. The statements regarding the category that concerns us most is this massive theft or embezzlement claims that they've, it's kind of a rolling number of about $600,000. And it is over, I believe, according to their pleadings, between 2013 and originally to 2017. Now they're trying to create something regarding 2018, but the fact is Daniel Watson had kicked her out of the company at the very latest in July of 2017. She had no, control of anything. And so our point about the statute of limitations is, look, you're going to say there are all these individual, misappropriations, if you will, or thefts or pilferings. Each one of those things, they just simply aggregate them. Well, a date certain, or at least in our minds, there are about 2 or 3 operative dates that if a particular, theft or conversion or whatever took place before a specific date, then it's time barred. And so they don't get to create a fact issue on things that are time barred by lumping them into as aggregate claim, because the fact is, and I haven't, and because they haven't pled it, and maybe I should have filed some special exceptions on this. I know that those have become a little bit more passé, but the fact is they have not, as we indicate in the pleadings, specified each individual transaction. They just kind of said between these periods of time. And so I think that once we establish, look, this was 4 years before, you absolutely cannot file, especially since you were put on notice of these things and you've acknowledged notice, in 2012 with respect to statements that you quote, Oksana is quote stealing from the company. But so I don't think that it would be fair to certainly not to Ms. Watson, but I also think it would be kind of confusing to a jury for them to kind of sit there and go, okay, well, there's an issue regarding some of this, and because I think that there might be with respect to some, but there are others that he's absolutely well beyond there's no fact issue.
I get it. Mr. Vassar, what's your response?
Your Honor, the fiduciary duty at this point has to survive in toto. You can't throw anything out in this point. At this point, Mr. Henley didn't say it, but he points out in their response the date of May 27th, 2016, and really concedes that anything after that date is fair game, because that's 4 years from when we filed. Well, I want to point out that as of that date, defendant was still an employee. She later absconded with computer equipment and books and records of the company. Angel Sword had yet to receive notifications of tax liability from several jurisdictions as a result of her misdeeds, and she had yet to set up automatic payments for car insurance from company accounts. And she had not yet contacted Intuit to try to put me in charge of all of the books and records of the company. All those things happened after May 27th, 2016. And I just don't think that, first of all that
there
stuff
were other things that you alleged. I mean, prior to 2016, there was a 2012 allegation, 2009. There's other things you've alleged before 2016.
Well, certainly, Your Honor. Certainly. I mean, some of the misappropriations occurred before then, but all those things happened after. And not only are they fair game, but they also implicate when could we have found out about it? If she's still on the job and she still has the books and records and the computers, and when we ask her to surrender them after she's terminated and she doesn't, then that's a real problem in when we are able to discover things. And the law recognizes that. A fiduciary, is going to cover their tracks. And we've cited you two cases that say that.
I mean, I do think that at least part of the breach fiduciary duty claim is going to survive. I do think we need to come up with probably a date, before which, I mean, that it's past the statute of limitations. And so I'm going to take a closer look at all this and we'll come up with an exact ruling on it. Let's move to the other summary judgment.
Okay, this is our summary judgment, Your Honor. And last year, as you may recall, the response from the defendant was this case needed to be moved to Hays County and consolidated in the divorce case. You denied that motion to transfer venue in October. Defendant changed her tack and filed counterclaims against my clients in February, third-party claims against Daniel Watson. And the claims we're on here today are for declaratory judgment that she either owned 50 or 100% of the company. And the factual background of that entity is set forth in our motion. I'm sure Your Honor has read it.
I've read it, yeah.
Pardon me?
I guess my main question is, what I think this comes down to is that the corporate documents specify one way to allow a transfer of shares to occur, and then Texas law has a different rule involving how a gift transfer is going to occur. And so which trumps under Texas law? Is it the gift rules are much more casual or less stringent than the rules of the corporation? Do you have any cases that talk about this? Mr. Henley, I think, cited to some, or I believe it was Mr. Henley, cited.
He cited to Maldonado. He cited to a 1946 case of Greenspun. And as we pointed out in our reply, Your Honor, we think those just don't apply here. And the first thing is there's just no intent to make a gift. You have the circumstances before you.
He specifically said he was doing it, and then he sealed it in blood. I don't know how much more intent can you have.
And he tells you the circumstances of that night of heavy drinking, marital arguing, following the Austin Opera. In his affidavit, says he did not have the capacity to transfer. Why would there at least be a fact issue on that?
I have to take as true that he didn't have capacity.
Your Honor, this is, the closest analogy I can think is this is the schoolyard bully saying, "Oh, scrawl an X, and I own all your baseball cards," and then the bully doesn't do anything about it until 4 years later. This was something that wasn't a serious, and she didn't take it seriously either, Your Honor.
Mr. Master, who's the bully? Is Miss Watson the bully?
Miss Watson knew he was drunk, said, give me the company, and seal that with your own blood. Mr. Henley, when he
so did she threaten him with a gun, or how was she threatening him?
Well, the circumstances of what happened that night are in my client's affidavit. Obviously, there's some differences in what defendant's affidavit says. But I just find it very curious that when Mr. Henley changed tact in this case, he made the bold capitalized statement, "Daniel gets drunk daily," in a heading, under which includes allegations of him passing out by midnight, wrecking cars, and then given the circumstances of the handwritten note, he's going to have you believe that he was sober as a judge. And that simply wasn't the case, Your Honor. This was not a serious conveyance, and it wasn't taken as seriously by the defendant.
Mr. Vassar, isn't that something a jury should decide? You're asking me to rule as a matter of law that he did not have the capacity based on his affidavit that he saw. He had the ability to. It wasn't the letter actually, it isn't like signing an X. He actually wrote the entire gift and sealed it with his own blood. He didn't just write an X and that was it. He actually wrote it all out, didn't he?
He did, Your Honor. If you want to take Mr. Henley at his word that this was a completely sober, above board transaction that was taken seriously by everybody, get out that envelope. I'm sorry for calling it a napkin. It is an envelope, and it says 100% Angel, new word, sword to Oksana. Angel Sword Corporation is still a corporation. It was once a plaintiff in this lawsuit, and she can go knock herself out with 100% of Angel Sword Corporation, because that's how that envelope reads, how that writing reads.
Are you saying that it's not the correct name of the corporation?
Angel Sword LLC, the active plaintiff in this case, is a mashed up word. There's no space between Angel and Sword. It's got a comma and an LLC. Angel Sword Corporation was its predecessor. It was once a plaintiff in this case. It has a space between the words angel and sword. So again, I'm not conceding that there's anything valid about this handwritten note, but if there is, if you want to take Mr. Henley at his word and his client at his word, angel and sword are two different words. In fact, they're on top of each other. And, that's a logical interpretation. That's as logical as anything else.
So, Mr. Vassar, you're not trying to argue that because it didn't follow the corporate formalities that we shouldn't enforce it?
No, we are absolutely saying that the company agreement was created to protect the owners of the company and the company from any kind of transfer that doesn't comply with 6.3 of the company agreement. Now, I think that's what led to them saying gift, 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 even though it was a gift of 100% of a man's livelihood, literally built with his own two hands in the midst of a drunken marital argument. I think faced with that, they turned to gift. And I think Your Honor made a very interesting point of, what takes precedence.
Judge, if I may.
I will say this, that, because I've seen this happen before, if I do question personally whether or not he might have had the capacity, just based on what I've heard and I understand. I don't know that's, so I guess what I'm saying, Mr. Henley, is if I do happen to deny the summary judgment, don't come back and try to, I guess you can do it, but I do think there's a capacity issue here, but I think it's probably one that needs to be decided by a jury, in my opinion.
Judge, if I may, I was going to share the screen. Oh, I guess.
I'll turn it back on. Go ahead.
Oh, okay. Can I do it now?
Yeah.
Okay. I wanted to, or I'm trying to share it. Oh, okay. Let's see. Oh, here we go. Can you see it? I guess not.
Yeah, we can.
Oh, okay. The envelope, is it up there, Judge?
Yeah.
Okay. First of all, all of this writing is his. And no one, Mr. Vassar wants to suggest that I said that this man, was completely sober. We haven't offered any evidence that said, that this man, hadn't had a drink that night. Both testimony came from wife and husband that they'd gone to the opera, they drank some, they went home and they were arguing and talked. They'd had a good time at the opera, but then they, went home and they were talking about their marriage. They were talking about Jeremy Levy. And then Watson, according to Ms. Watson, goes ahead and says, look, if you think that you're worried about, your status or about, being left, then I'm going to give you 100% of the corporation of the business that we have. And it's not like, if he's going to assert that, if Mr. Vassar is going to assert that, Daniel Watson gave, couched it such that, well, I'm going to give you 100% of nothing to make you insecure. To make you secure. That's absurd. When in fact, when you look at the writing itself, it says 100% Angel Sword. And there's a perfectly good reason why Daniel Watson chose 2 lines for it, is there's other writing next to it, which is the address for the Austin Opera. Then you look at number 2, it says to Oksana. Number 3, he signs it with his full signature. Number 4, he gives it an initials. Number 5, he gives a date. And then I guess it's number 2, he gives donative intent. He says, to my lovely wife. And then number 4, he initials it. And then finally, of course, the coup de grace, he does something that I don't think that Your Honor probably has ever seen. I've certainly never seen. He seals it in blood. And, to suggest that this isn't, donative intent is absurd. And when you look at the case law regarding undermining gifts based upon intoxication, they're not saying, look, you can't go to a bar, make a deal, or convey something after you've been drinking some wine, or even if you're tipsy. The case law requires that you are so out of it, you are whacked, you're going to pass out. It's very similar to the various differences with intoxication concerning how drunk you can be to walk down the street versus how drunk you can be to operate a motor vehicle. There's vastly different standards. Well, this isn't operating a motor vehicle. This is somebody expressing his intent. He did it. I didn't do it. And Mr. Vassar keeps on wanting to say that, it's my testimony or my framework. I didn't do this. Your Honor didn't do this. I don't think either one of us would do something like this, but he clearly did it, and he meant to do it. And so the idea that Mr. Vassar would try to, and I understand it. I mean, he's a serious individual, and he thinks that, and he doesn't want to say that, he has a lunatic client who would do something like this. But the fact is, this is what he did, and we have to take him seriously. We have to take him at his word. He dated this letter. Or the envelope, he dated it, he specified his intent, he signed it, he initialed it twice, and he signed it once. And of course, this all happened during the course and scope of their marriage, which, by the way, Judge, they formed that entity, Angel Sword LLC, during a decade after they've still been married. So at the very inception, Angel Sword LLC, as we point out in our briefing, it's a community asset. And they haven't done what they're required to do, and that's to marshal clear and convincing evidence that takes it out of the community estate. And indeed, it's worse than that. It wasn't just simply the fact that it was formed after the marriage, a full decade thereabout, but it was also formed using money that had been commingled, and thus, at the very inception, this Angel Sword LLC was a community asset. And then on this particular day, he conveyed, because apparently he was genuinely sympathetic to the notion that Jeremy Levy was going to crowd Oksana out, that he would go ahead and just convey the whole thing to her. He would know that, he was going to continue to work it, but, to make her feel more comfortable, he gave it to her. And this is the evidence.
So let me just focus on one issue that I am struggling with. So I'd like, you can take that down. I appreciate seeing that. It's interesting.
Stop share. Okay.
So the main issue in my mind right now is just which rules trump the rules on gift giving, because I think that there's probably a fact issue, but on whether or not this was a proper gift or not, or do the rules, or if you have a situation like this where there's a gift, do you have to, or a transference of ownership, do you have to go through the process set forth in the corporate documents? Mr. Vassar, why don't you kind of share screen any cases you have that would support your position on that?
Yeah, our position is they've got to comply with the corporate formalities. We did cite a case at Abduliev.
Did you spell that?
Mr. Predictably had a problem with because that case said if you don't follow the corporate formalities.
Is that the one out of Illinois?
Pardon me?
Is that the case out of Illinois?
No, the Illinois case involved tax returns, Your Honor, and we have a disagreement about that. The case that I'm talking about is out of Texas. They said if you don't follow corporate formalities in transferring the business, then it's an ineffective transfer. Mr. Henley pointed out and will point out that those regulations, unlike ours, said any attempt to do so is null and void. But I think we cited the case not for that, but for the fact that if you don't follow these corporate formalities, they've got to mean something, Your Honor. If 6.3 of your company agreement says you can't have a transfer unless you have a registration or an opinion of counsel that no registration is necessary, then you don't have an effective transfer. And the only specimen certificate that was ever issued was issued to Daniel Watson. The only other thing I'd say, Your Honor, is regardless of what you think of the gift, whether it trumps the 6.3 of the company agreement, we talked about limitations with the last motion, and I think it's time to talk about limitations with this motion, because no action, you saw the date on there ad nauseum, 1/19/17, and no action was taken until February of 2021.
Let's talk about the big picture here, which is, we have a trial setting coming up in 3 weeks or so. Is that right?
Yes, Your Honor.
I'm not going to rule on this today. I do want to read some of the cases, but do we want to try to keep that trial setting, or do you want to get this case is relatively new, so the chances of getting reached are. Let me just look at the docket. What day is this case set?
27th.
Look at the docket.
I think there were like 11 cases in front of us. Mr. Henley may have looked at that also.
I have not, actually.
And what's your, let's see. So let me just kind of share screen here. We do have, it looks like, 20 cases set. We need to look at the cases that are older than yours that are jury trials. So, so these first 3 cases are all newer than yours, so you go ahead of them. The 5th case is the 6th case. So this case, Wright versus Hernandez, it's listed as a non-jury. Let me see if they've actually, I would be surprised if it's actually a non-jury. They did a jury demand. Let me see. And they paid the jury fee. So that case will be ahead of you. Sorry about this. So this case is ahead of you, Wright versus Hernandez. That's case older. So these 2 cases, this case is a big one. This Ralph Lumens versus Richmond Trust. These next 2 are pretty big. So those cases, say there's 3 cases ahead of you, 4 cases, that's you. 5, that's a non-jury. So 4 cases. I don't know about this Weaver case. That's actually a jury case. 5 cases, 6, 7, 8. Yeah, so there's about 9 cases ahead of you. I don't mind keeping you on that date because it's going to be like that kind of probably any time we set you. But Do you guys want to keep that date? If everyone agrees, I'll move it. Or if anybody disagrees, I'll just keep it and you can file a motion for continuance or whatever you want to do.
I'd be fine with it moving. We've had a Sunday deposition ordered and obviously some things to take care of given what happened today, especially with what the court does with our summary judgment motion. And I don't know what your take is on limitations, but I would be happy to talk about that further.
My thought on limitations for that first motion you have is that I'm probably going to deny it, but I'm going to set parameters on how long the case, like how far back you could possibly go, but we'll see.
Right, and I'm also talking about limitations on our affirmative motion because she did not take action in 4 years. Whether it's a gift, a transfer, 50%, 100%.
Let's talk about the trial setting right now. Mr. Henley, what do you think? Do you want to keep the trial setting to see what happens, or do you want to move it?
Well, I do think that, how Your Honor rules on the matters that have been presented today certainly affects, they would affect a lot in terms of, but, I'm relatively agnostic about, I would probably prefer to move forward, but I also saw, as I'm sure all of us did, Your Honor, pointing, to, I guess, some 9 to 11 cases, including 2 or 3 that I gather by the tone of your voice were complex.
I've just had a lot of hearings on those 2 cases. I think it was maybe 3, but 2 cases for sure. I've had a lot of hearings on them. Now that doesn't mean that they're going to go. I haven't heard from them super recently, but yeah, those are definitely older than you. I'm not trying to talk you into moving it or not talk you into moving it, but since we're all here, I was thinking, hey, if you want to move it, if we all agree, but if you want to talk to your client and, whatever you want to do, I'm not trying to, Mr. Henley, pressure you in any way to move it. Because I don't know there'll be another date that will be better. It's just, I know this case is it's not a little one-day car wreck that you can just reset. It's going to take time to get ready, but whatever you guys want to do.
No, I appreciate Your Honor. And I didn't think that you were trying to, back me or even opposing counsel into a corner regarding anything. I think you were just really trying to ascertain what it is that we want. I'm perfectly fine with keeping the setting and trying to get moving the ball toward resolution. I'm not excited about the idea of a setting, though, that is not terribly likely to result in.
Have you already been to mediation on this or not?
No, we have not.
Your Honor, I emailed the mediator twice this week for dates before the trial setting and never heard back. So
who's the mediator?
Something else that needs to probably happen.
Who's the mediator?
Jeff.
I don't know, actually. I mean, this is an unusual case for me, Judge. This isn't, this isn't a crash. So I'm not even sure who would be, I know that Mr. Vassar and I certainly haven't had any discussions about any of that. So
would this be good for like a former judge to try? Because it's a pretty complex but not huge case. So going with somebody like a Chris Nolan might be cost prohibitive, but someone like Jim Jordan or King Pfeiffer or Carl Ginsburg or someone like that.
King Pfeiffer certainly would be fine. I agree with your assessment regarding Chris Nolan. This isn't a security transaction between Fortune 100 corporations. They certainly don't have the resources, or at least Ms. Watson doesn't, to have for a $3,000 a day mediation. But somebody like Judge Pfeiffer we would certainly be amenable to him.
Do you want me to call Burden Mediations and see what their availability is, or or what do y'all want to do?
That would
I
be
guess for now.
I think it's Metcalf is the mediator that we have now.
Oh, Metcalf. Yeah, he's a good mediator. He's actually mediating a case, another one of my cases today. So he's a very good mediator, and he's not super expensive, but he's a former judge, but many, many years ago, and one of my first mentors as an attorney. So, but I'm okay with moving him. Why don't we just do this? You guys talk about if you want to move the trial setting. I'm going to try to get you a ruling within the next 2 or 3 weeks on these summary judgments. I don't anticipate that this case, even if I granted the portions of the summary judgment I'm considering granted, the case is still going to be there. You know what I'm saying? It's just, I'm not going to grant the case. There'll be still something to fight over. Part of the breach of fiduciary duty case is going to survive. In all likelihood, this issue about the gift is probably going to survive. And so there's going to be stuff to fight about. So you're going to have a case to try. It's just going to be what's the exact parameters. Have you finished all your discovery you need other than the one deposition?
Well, I would like to go ahead and depose, as we were talking about Mr. Watson. One of the things, Judge, that I didn't mention earlier, and I meant to, was for the first time, I learned as a result of reading their motion for summary judgment that the company agreement actually specified, and this was the agreement that purports to give Daniel Watson 100% interest, specified that all disputes associated with Angel Sword LLC will be filed in Hays County. And had I known that, I absolutely would have included that in my motion to transfer venue, way back when. That train may have left the station. That
wasn't, because I saw that too, and I was a little surprised that wasn't brought up though previously that I'm aware of.
And I did, the first time I saw it was in Mr. Vassar's motion for summary judgment on this other issue in reviewing the documents. And I haven't, because I can assure you of this, if I had seen that I would not have spent, hours and hours analyzing whatever those credit card transactions were and doing all the math associated with it and everything that they've had, parsing the percentages and how much purportedly was taken, in Dallas County versus Hays and Travis, which of course had said something was like less than 2%.
Are you saying you're going to want to, I guess my question is, I wasn't aware of that very well might have, I'm not saying it would have, but might have changed my, choice of venue clauses are strongly favored by the Supreme Court. And so that might have changed. I just don't remember ever seeing that.
No, I didn't either. And again, it would have been for the purpose of, because we had multiple bases in our motion. One was, dominant jurisdiction because the family law case had been around. It was first filed, but two, there was a form.
Let me just say this. If the parties all agree that we need to rebrief that issue, the motion to transfer venue, I do think there's probably a waiver issue, but if you guys are wanting to do that and you all agree, I'm glad to move the trial setting to let him refile the motion to transfer venue. There's a pretty good argument that it's been waived, I think, but if that's not something you guys want to fight about.
We don't, Your Honor. We didn't get a request for production until April. So that's part of the reason that wasn't part of the motion to transfer venue. So there's clearly a waiver.
And Judge, I would weigh in too. They're not seeking to enforce the agreement. I understand Mr. Hanley's arguments. They're not seeking to enforce anything in that agreement. In fact, they're trying to sidestep the agreement altogether and say they have some equitable right, either through gift or otherwise. So the agreement itself is not really operative at this point. It's not something they can stand on.
And of course, we agree that the agreement itself is not operative anyway. But the fact is we absolutely feel sandbagged with respect to that venue provision.
It would be a complicated issue. I'll just say that. I don't know that I would transfer it or not. I don't know that it's the operative agreement. I agree with Mr. Ellis there. I think that there's a very strong argument on waiver at this point. That being said, what I'm going to do now is just keep the status quo. The case is still set on the 27th. If you guys want to move for continuance, if you want to move to transfer, whatever you want to do, I'll try to get you a ruling within the next 2 or 3 weeks on the summary judgment, but I can assure you that there will be portions of the case left alive. And anything else we need to chat about today?
I don't believe so, Your Honor.
No, Your Honor. Enjoy the rest of your vacation.
Thank you so much, guys. You have a great day, okay?
You did the same,
Thanks,
Judge.
everyone. Have a
Happy
good football.
holiday.
And if the